Welcome, and thank you for joining us today. Please be aware that this presentation is being recorded for future viewing. I'm Dee Simon, the Barral Family Executive Director of the Holocaust Center for Humanity. I'm thrilled that over 950 people have registered for today's event. I invite you to join us every Tuesday for our weekly Lunch and Learn programs, and on September 25th for our Voices for Humanity virtual event. I'd like to thank today's program partners, Perkins Coie, Karr Tuttle Campbell, and the Jewish Federation of Greater Seattle's Cardozo Society. I'd also like to thank the members of our Lawyers Committee who helped organize today's program, Ruth Atherton, Mark Bowman, who sits on our honorary board, Kathy Feldman, Avi Lipman, Gordon Lotzker, Chuck Madwell, Jay Rifkin, John Rosen, Rob Spitzer, and Jeff Sprung. And a special thank you to our board member, Ron Friedman, and our development director, Nicole Bella. For those of you who are joining us for the first time, the Holocaust Center for Humanity has been serving the Northwest for over 30 years. In 2015, we opened our new museum in downtown Seattle. Annually, the center reaches about 40,000 students and community members. It's through the lessons of the Holocaust that we teach students of all ages to confront racism, bigotry, and indifference, promote human dignity, and we challenge individuals to take action. Today, these lessons couldn't be more critical. Studying the Holocaust gives us an opportunity to examine a society that turned against its own people. In our program today, we'll examine the role of the legal system. We're proud to bring this program to our legal community and to the general public. It's now my pleasure to introduce Ruth Atherton. Ruth is Deputy General Counsel at the Bill and Melinda Gates Foundation, primarily responsible for legal services to the Foundation's Global Health Divisions and its Medical Research Institute. Thank you, Ruth, for participating in today's event.
It's been an honor to be part of the legal committee for the Holocaust Center for Humanity to help plan today's program. Thank you all for joining us, whether you're a lawyer or a law student or a member of the community interested in the topic. We're incredibly excited to have you here today for this special program. And I would like to thank the generosity of the Holocaust Center for Humanity for making this program freely and widely available to all. For those of you here today seeking 1 hour of Washington State CLE credit, please note the following. In order to receive credit, you will need to attend the entire program. During the program, Nicole Bella will announce a word that you will need to record on your affirmation form. You should have received the affirmation form before today's program. If you did not receive it, you will receive another copy in the post-event email. Please return your completed form to nicole@holocaustcenterseattle.org in the next week. We also appreciate you filling out the online evaluation form at the conclusion of today's program. It is my pleasure and honor to introduce our speaker, Professor Lawrence Douglas. Professor Douglas is the chair of the Law, Jurisprudence, and Social Thought at Amherst College, holding degrees from Brown, Columbia, and Yale. Professor Douglas is the author of 7 books, including the acclaimed The Right Wrong Man, and other fascinating works that you can find in your local bookstores and online. His commentary and essays have appeared in Harper's, the New York Times, the Washington Post, the Los Angeles Times, and the Guardian. He is the recipient of multiple fellowships, including from the National Endowment of the Humanities, the United States Holocaust Museum, and the Carnegie Foundation. Please welcome Professor Lawrence Douglas.
You need to activate my video. Hello, the host needs to activate my video. Hey there. So, thanks so much for the kind introduction, Ruth. It's a pleasure for me to be with you this afternoon. I know we have both lawyers and non-lawyers in attendance today, and I hope my remarks will be of interest to both groups, and I hope also to leave a sufficient amount of time at the conclusion so that we can have some question and answer. For the lawyers joining us today, I want you to remember back to your course on criminal law, assuming that that is not a traumatic memory. And as you may recall, the law typically views criminal acts microscopically. And what I mean by that is it tends to construe crimes as deviant acts. That is, acts that are committed by individuals against other individuals or against property, and that these acts are understood to constitute threats to social order. And in this model, it's the state that's understood as the bulwark of security and order and lawfulness itself. Obviously, individual state actors might be bad. We could consider the police killings that have sparked the recent Black Lives Matter protests. But in general, the state itself is understood as, again, kind of a source of order. And it's also understood to be restrained by the very laws that it promulgates. I think it's fair to say that Nazi crimes exploded this legal model, and its assumption that violence committed by individuals and small groups represents the most basic threat to the fabric of social life. So I think we can say that Nazism revealed the terrible capacity of the state itself to turn reprobate. And this is a phenomenon that the German philosopher Karl Jaspers designated with the term Verbrecherstaat. And again, so we see this very formidable looking German word, and all that word Verbrecherstaat means is the criminal state. And I think what Jaspers was trying to do in coining this term, criminal state, was to illuminate how Nazism had turned the state itself into the principal perpetrator of crimes, that is, the very agent of criminality. Now, in his opening address at the Nuremberg trial, Chief Justice Robert Jackson, and as some of you might know, Jackson had taken a leave of absence from his position as Associate Justice on the US Supreme Court to lead the American prosecution at Nuremberg. Jackson framed the legal challenge posed by the Verbrecherstaat in these terms. Civilization, Jackson said, ask whether law is so laggard as to be utterly helpless to deal with crimes of this magnitude by criminals of this order of importance, end quote. And here we see an image. This is of the defendants here in the dock at the International Military Tribunal at Nuremberg, which I should mention is about to celebrate the 75th anniversary of its start. And it was, we should recall, the very first international criminal court in human history. So the Nuremberg trial, I think, offered a distinctive answer to the question that Robert Jackson had asked. Nuremberg insisted that law was adequate to the task, but the effort would require extraordinary legal innovations. mastering the crimes of the Verbrecherstaat, the criminal state, it would require first and foremost new categories, novel categories of wrongdoing. And these novel categories of wrongdoing, they would have to be sufficiently flexible and capacious in order to handle crimes that had spanned an entire continent, that had enlisted the participations of tens of thousands of perpetrators and accessories, and that had been supported, of course, by the complex organizational and logistical apparatus of the modern nation state itself. And these new incriminations, that is, that's a word that just means legal category of wrongdoing, these new incriminations would have to be able to penetrate the shield of sovereign immunity that had traditionally insulated state actions from outside legal scrutiny. Now, the two most important legal innovations to emerge out of post-war justice were crimes against humanity and genocide. Now, Nuremberg was not in the first instance a trial about the extermination of Europe's Jewish population. And what we have here in this image, this is actually the statute of the Nuremberg court. And these are the three crimes that the Nuremberg court had jurisdiction over. And as we see here, right here at the top, we see that the main charge against the 21 defendants in the dock was that they had committed these so-called crimes against peace. That is, that they had planned a war of aggression in violation of international law. But Nuremberg was also the first trial in history to confer judicial recognition on this thing that we see down here, crimes against humanity. And this was the charge that Allied prosecutors used to bring much of the evidence of the Holocaust before the International Tribunal at Nuremberg. The second great legal innovation was the concept of genocide. And this was the term coined in 1943 by the Polish Jewish jurist Raphael Lemkin. And here we see a Lemkin pictured with his tie casually loosened in a rather typical pose for Lemkin. And Lemkin specifically coined the term to describe the Nazis' treatment of Jews in occupied Europe. And what he did is he took the Greek word for group, genos, and wedded it to the Latin word for killing, side, and came up, of course, with this new term, genocide. And by this, Lemkin sought to name something graver than just mass murder. So in Lemkin's term, genocide meant to designate, and this is a quote from Lemkin, the destruction of the essential foundations of the life of groups with the aim of annihilating the groups themselves. And in 1948, with the framing of the UN Genocide Convention, and here you can see right here, you can see this was Lemkin's identification pass itself for participating in the United Nations Genocide Convention. So already in 1948, with the Genocide Convention, genocide became recognized as its own independent crime in international law. These new incriminations, again, by incriminations, I mean these new categories of legal wrongdoing. These new incriminations gave prosecutors powerful tools to pursue those who had committed crimes of the Verbrecherstaat, the criminal state. And more recently, they have also enabled the prosecution of people who perpetrated mass crimes in places such as Cambodia, the Balkans, and Rwanda. But the one nation in which these legal innovations proved less than useful was Germany itself. Now, Germany, I think, enjoys something of the reputation of having confronted its Nazi past with impressive thoroughness. But I think it's also fair to say that when it came to bringing Nazi perpetrators and collaborators to justice, the Federal Republic's legal system amassed a deeply problematic record. And the problems facing post-war German jurists really were pretty profound. And I do want to emphasize that I'm talking about the Federal Republic of Germany, what was then West Germany, what we now refer to as Germany. East Germany kind of represents something of a different case, and that's not really directly germane to what I'm talking about right now. Now, some of you might be familiar with the notion coming from military law that so-called superior orders does not constitute a defense. And for those of you who are less familiar with this idea, let me just try to very quickly explain it. If your commander, if you're in the military and your commander orders you to commit an act that you know to be a manifestly criminal violation of the law, you're obligated not to follow that command. So in a clash between command and the law, we can say the law wins, or the law should win. But what happens when the law itself appears profoundly or even horrifically criminal? What then? This raises, I think, an even more profound and foundational question. That is, what are the obligations of jurists and state officials to follow the law of a Verbrecherstaat, of a criminal state? Or we can even ask, what even counts as law in a Verbrecherstaat, in a criminal state? Now, these ethical questions were not just abstract questions. They had to be answered by Germany's post-war jurists as they struggled with the legacy of Nazi atrocity. Germany, as some of you might know, it reclaimed its at least partial sovereignty in 1949, and almost immediately, its courts concluded that because genocide and crimes against humanity had not been formally recognized as crimes until after the war, that charging former Nazis with these crimes would violate the fundamental principle of legality. And here we see the fundamental principle of legality. And for those of you who might have blundered into Latin courses when you were younger, you might be able to recognize these phrases, nullum crimen sine lege and nulla poenus sine lege, as meaning no crime without law and no punishment without law. And if that still remains a little opaque, I think the idea of this basic principle of legality is that it would be fundamentally unfair to hold a person criminally responsible for conduct that was not deemed by the law as criminal at the time that it was engaged in. I think for American lawyers, the principle of legality in these Latin formulations is more familiar to you in the Constitution's prohibition on ex post facto law. So let's just make sure that we get what's going on here. So German courts concluded that trying former Nazis for crimes against humanity or for genocide would involve an impermissible, really an unconstitutional violation, because it would constitute an application of ex post facto law. Now, you can probably imagine that this conclusion was pretty controversial. And in fact, no other European nation followed it. And I don't exactly have time to go into the exact nature of the controversy right now. If you have questions about it, I'd be happy to address those later on. But what it meant was that the very devices that had been designed to facilitate the prosecution of Nazi exterminators, that is, again, crimes against humanity and genocide, that these legal devices were off the table for German prosecutors. So this, of course, raised a thorny question. What charges could be brought against former Nazis in Germany? Now, given the posture of post-war German jurists, only an incrimination in place during the Third Reich could survive a challenge based on retroactive application. Now, I just want to repeat this because I just want to make sure that the non-lawyers and the lawyers, that we're all rowing in the same boat. So what this meant really was that to avoid the ex post facto problem, post-war prosecutors could only charge former Nazis for breaking laws that were already in place during the Third Reich. Now, I suppose theoretically speaking, post-war German jurists could have concluded that even the worst Nazi atrocities violated no law that had been in place at the time. But that result, that conclusion, to use the technical legal term, that conclusion would have been crazy. And I say it would have been crazy because it would have meant that no one involved in Nazi extermination could have been prosecuted in post-war Germany for anything. And obviously, such a conclusion would have badly tarnished Germany's attempt to rehabilitate its image in the eyes of the post-war world, and also to reconstitute itself as a nation that was robustly dedicated to the rule of law. That notwithstanding, we still have to ask, did Nazi atrocities constitute laws, or constitute crimes, I should say, under laws that had been operative at the time, that is, during the Third Reich itself? And even today, I should say, historians and jurists offer conflicting answers. So let's for a moment consider Hitler's directive that was issued in October 1939. And this was a directive, again, from Hitler that authorized the killing of those suffering from so-called mental and physical disabilities. In a recent book called Reckonings, Legacies of Nazi Persecution and the Quest for Justice, a quite prominent British historian named Mary Fulbrook observed that Hitler's directive, and this is a quote from Fulbrook, was never legalized. It only had the force of Hitler's personal order, not the force of law, end quote. Now, that might sound good, but it raises an immediate question. What did the force of law mean in the context of a Verbrecherstaat, a criminal state such as the Third Reich? So, on the other side, leading German scholars of the law of the Third Reich, such as a scholar named Gerhard Wehler, they have argued that in the deformed legal world of the Third Reich, the will of the Führer, that it indeed had the force of law. Indeed, it had the force of law, regardless of whether Hitler's words were issued in written or oral form, or even took the form of a secret order. Fulbrook tried to respond to that argument by saying that Hitler's order couldn't have been law because, again, this is now just a short quotation from Fulbrook, because it, quote, was never translated into legislation. But again, here we have to ask, what does this mean in the context of a criminal state such as the Third Reich? After all, Hitler's Germany had no functioning legislature. In fact, it vested the legislative function directly in the executive, which is simply a short way of saying it vested it in Hitler himself. So in a way, to contrast Nazi legislation with Hitler's secret orders or his oral commands is to offer a distinction without a difference. And again, I want to emphasize that this debate is hardly academic. This is not just something that professors argue about, when they don't have more worldly questions to occupy themselves with. It really goes directly to the very heart of the question of whether German courts would be able to charge post-war, basically former Nazi perpetrators of violating law that had been operative at the time. So let's consider another deeply horrific aspect of practices of the Third Reich, the Nazis' most emblematic and horrific atrocity, the mass killing of the Jewish population of Europe. Was that lawful in the Third Reich? To answer this, I actually want to turn to what looks like a rather grotesque source. I'm going to look at how the SS courts themselves handled this question. Now, it might come as a surprise to you that the SS actually had its own court system, but in fact it did. And in fact, it punished SS men, particularly for corruption. And the punishment for corruption could actually be quite severe. So for example, a SS officer named Karr Tuttle Campbell, he had been the former commandant of the Buchenwald concentration camp. This Koch was famously convicted and executed, but not for his brutal running of Buchenwald, but for his corrupt stewardship of Buchenwald. And there were SS judges such as Konrad Morgen, and here we see an image of Morgen. This is his personal identity card. And Konrad Morgen was the SS judge who in fact was responsible for prosecuting and condemning Koch. SS judges such as Morgen saw themselves as scrupulous upholders of SS law. And they were kind of seemingly oblivious to the insanity of fastidiously upholding legal standards in a completely perverted legal system. So in applying the then operative German law of murder, because obviously Germany still had a murder statute on its books during the period of the Third Reich, in applying the then operative murder statute, Morgen recognized three forms of acceptable or lawful killing. So again, if a killing was either an example of euthanasia, that is, again, by euthanasia, we're really talking about the murder or the elimination of the physically and mentally disabled, or if a killing took the form of an execution at a concentration camp, or more astonishingly still, if a killing took the form of part of the officially decreed extermination of the Jewish population of Europe, then it was not considered a punishable crime under SS law. So again, just to kind of remind us what I've just said, by the lights of SS law, if the killing of a Jewish person fell into one of these categories that I just described, then it was lawful. A killing that did not fall into one of those categories, however, was not. So, for example, herding Jews into gas chambers or shooting Jews in mass graves was acceptable, and it was legal if it was part of the campaign of systematic extermination. But shooting Jews for sport was not. And that's exactly what this SS lieutenant Max Teubner, who we see pictured here, that is exactly what Teubner was convicted of in the end of May 1943, that is, of engaging in sport killing of Jews. Again, he was tried and convicted by an SS court. And the SS court insisted that in killing for sport, Teubner had violated, and again, this is a quote, the German way of conducting the necessary extermination of the worst enemy of our people, end quote. Indeed, in killing for sport, Teubner had, so the court reasoned, engaged in what the court described as, again, this is a quote, Bolshevik methods, end quote. Yet for all his disorderly Bolshevik-style killings, we have to ask ourselves, what exactly was Teubner guilty of? Was he guilty of murder? The answer is no. Rather, Teubner's offense was breach of troop discipline. So this handling of the case became characteristic of how the SS courts in general treated the unauthorized killing of Jews. Again, not as murder and not even as manslaughter, but as acts of disobedience or acts showing insufficient troop discipline. And underscoring the bizarreness of this reasoning, the SS court considered whether Teubner's killings had been motivated by base motives. Now, just to be a little bit technical here, base motives was one of the factors that the then operative murder statute used to elevate a case of killing to murder. So if you had engaged in an act of killing, and if a court was able to demonstrate that you had base motives in your act of killing, then, again, during the Third Reich, under the then operative murder statute, that act of killing could be brought up to the level of murder. But here the court reasoned that, and again, this is a quote from the court, that the driving motivation of the defendant has been genuine hatred of Jews, end quote. Now, we might be tempted to think that evidence of race hatred actually constituted then a base motive, but not for the SS court. Quite to the contrary. The SS court reasoned that because Teubner had had genuine hatred of Jews, that counted as an exculpatory factor for him. That is, the fact that Teubner was motivated by a hatred of Jews was for the court an indication that he had not acted out of bloodlust or greed or any other base motive. That is, to his credit, he had shared the proper view that, quote, Jews must be exterminated, end quote. And so again, it was Teubner's methods, not his motives, that demanded punishment under SS law. And this came in the form of 1 year in prison. And in a fitting footnote to the case, a German post-war court concluded that Teubner could not be retried for his vicious sport hunting of Jews because of the bar against double jeopardy. And again, this is the idea that, again, probably is familiar to a number of you, that you can't be convicted of the same crime twice. And if you think about it in this way, post-war German courts actually treated the verdicts of SS courts as legitimate judicial pronouncements for the purposes of applying the double jeopardy bar. The post-war trials of those accused of perpetrating and assisting Nazi-era atrocities, I think it's fair to then say that they showed both disturbing continuities and important breaks with SS jurisprudence. The most important break had to do with the question that I raised earlier. That is, post-war German jurists ultimately did use the then operative murder statute to try those who ordered and participated in Nazi atrocity. And perhaps in the sharpest repudiation of SS case law, post-war German courts now treated race hatred as a base motive, not as proof of its absence. Now, this might strike us as a utterly obvious and necessary correction of an odious doctrinal aberration from the Nazi period. But here again, that ex post facto bugaboo, that concern about ex post facto law, raised its head. In the mid-1970s, there was a German law professor named Ernst Walter Hanek, who raised the question whether race hatred, and this is a quote from Hanek, whether race hatred, quote, which from today's perspective looks like an obvious case of base motives, can actually be applied without violating the bar against retroactivity. So Hanek insisted that what constitutes a base motive is, quote, an ideological construct, end quote. Hanek argued further that now using race hatred as a criterion of culpability was to, quote, judge the behavior of the perpetrator from a viewpoint that was not valid in the legal order in which the perpetrator acted, end quote. Now, Hanek recognized that his conclusion might have been shocking, but his larger point really wasn't to defend Nazi perpetrators or really to criticize, it wasn't to defend Nazi perpetrators, it was more to criticize the post-war German obsession with this kind of issue of retroactivity. After all, if the decision to implement a continent-wide campaign of murder doesn't indicate some base race hatred, it's really hard to imagine what does. So German courts ultimately, as I said, did use the German murder statute operative during the Third Reich to try former Nazis. But really in doing so, what post-war courts did is they, in a sense, held the entire leadership of the Nazi state to have been simply a gang of criminals. And according to this understanding, and I hope this is important, and I hope you get the point that I'm driving at here, that according to this understanding, the state as a totality had not been criminal. It had not been a Verbrecherstaat in Karl Jasper's parlance. Instead, what the post-war German judiciary basically argued was that the administration of justice, but not the law itself, had been hijacked by Hitler and his gang. So the law itself, such as the law of murder, had remained intact, even if at the time the proper enforcement was never done, and even if the Nazi leaders, in a sense, had been the worst violators of the law itself. So what can we say about what I think we could describe as a legal fiction? Now, it certainly was convenient because it did smooth the way to Germany's post-war prosecutions of Nazi criminals. Not that these were all that impressive. Indeed, the need to pigeonhole Nazi atrocity into the then operative German law of murder, it actually created gross complications for post-war prosecutors. And particularly one of the problems arose from the fact that the German law had this bewilderingly subjective standard of what a perpetrator was. And I won't go into great detail about this, but just to kind of give you a thumbnail sketch, this doctrine held that those who killed with their own hand, could only be considered a perpetrator of murder as opposed to an accessory to murder. They could only be considered a perpetrator if they basically fit the Hollywood stereotype of an SS sociopath. By contrast, those who engaged in hands-on acts of killing, but did so by order, they were treated by post-war German courts as just mere accessories. Again, just to be clear about what we're saying here, German courts treated SS men who engaged in hands-on acts of killing, that is, who shot Jews in mass graves, not as perpetrators of murder, but simply as accessories, as long as the defendants could claim they were simply following orders. Now, by contrast, persons who fit the classic definition of accessories, that is, for example, let's say SS men who might not have killed with their own hands, but let's say assisted these killing units, or maybe served as guards at death camps, but you couldn't actually show that they had killed with their own hand, that these folks, well, they were treated as guilty of nothing at all. So in cases in which an individual act of hands-on killing could not be proved, successful prosecution in post-war Germany was basically impossible. And needless to say, the very efficiency of SS killing operations guaranteed that there were very few survivors who could testify against SS officers. And the need for a survivor to testify in detail about a specific act of hands-on killing that they had witnessed, well, that was necessary simply to prove accessoryship. Well, that essentially disabled all German post-war prosecutions of thousands of guards. In treating acts of state-sponsored extermination really as no different from ordinary statutory murder, German courts, I think it is then fair to say, created huge obstacles for post-war prosecutors. And I suppose for those of us inclined to cynicism, we might say that was the point. Yet the legal fiction that made this possible, again, just to emphasize, the notion that the entire Nazi state had been in violation of intact then operative law, that legal fiction also reminds us, I suppose, about the quip about the preparation of sausage, that we shouldn't examine it too carefully. There was, however, a more radical solution to the problem of post-war trials. And this was the approach advocated by Gustav Radbruch. And Radbruch was one of the great German jurists of the 20th century. And he had, in fact, been a former minister of justice during the Weimar Republic. And in 1946, barely a year after the war's end, Radbruch articulated his theory of lawful illegality, which we see here, or with the German term gesetzliches Unrecht for some of you out there who might know German. And this was the notion that law, even if properly promulgated, ceases to have the properties or the qualities of law if it is intolerably unjust. So, for example, Radbruch famously argued, it's a quote from Radbruch, does one really want to draw the conclusion that acts of institutional murder must go without punishment because they're based on a secret order of Hitler's, end quote. Now, what was distinct and I think radical about Radbruch's approach was that it didn't try to draw some specious or even maybe untenable distinction between Hitler's orders on the one hand and some putative proper legislative act on the other. Instead, Radbruch recognized that Hitler's orders were, in a sense, law, but that they were nonetheless illegal. In Radbruch's approach, it was absurd to claim that Hitler's orders weren't the law of the time, but it was equally absurd to claim that such law should provide any shield against post-war prosecution. So as I've already suggested, Radbruch's formula did not carry the day. And I don't think we really should be surprised by this. The idea that law is both law and not law is, after all, an awfully difficult concept for lawyers and judges to wrap their minds around. Yet it was Radbruch's understanding that I believe best captured the disturbing truth of the Verbrecherstaat, of the criminal state. Because the criminal state itself, the criminal state reveals that law itself, that is our supposed bulwark of security and order and normative rightness, that law itself remains vulnerable to being deformed into an instrument of atrocity and destruction. So thanks so much for your attention, and I'd be happy to answer whatever questions you have.
Well, thank you so much, Lawrence, for this really great presentation. Before we move into the questions and answers, though, Lawrence, just want to do a quick reminder, because we've had some questions on this, that for all legal professionals on this program, that in order to get the ethics credit, you need to fill out the affirmation form after this program, and you should have received it before, and you'll receive it again as well. And that long anticipated code word that you've all been waiting for to get that CLE credit, the word is humanity. So just again, the word is humanity, and that is the word you should put on your form and mail back to me, or not mail, email to me at nicole@holocaustcenterseattle.org. And please feel free to also email me if you have any further questions about that. And again, that word is humanity. Okay, now going into a lot of great questions. I'm just going to start with this first one, Lawrence. Under what legal ground the Nazi regime was able to remove the citizenship of German Jews, and what laws were applied for that?
So a very early law was, of course, the Nuremberg Law that was passed in 1935. And the Nuremberg Law of 1935, it removed full citizenship from the Jews of Germany. They remained subjects of the German state, but they were no longer full citizens of the German state. And, you know, one of the things, I mean, I could spend a lot of time just talking about that Nuremberg Law of 1935. One thing I will point out is it raised, again, an interesting definitional question, which is what constitutes being Jewish for the purposes of the law. And in fact, there were pretty elaborate jurisprudential debates as to what constitutes a Jew. And alas, I have to point out that in trying to resolve those debates, German jurists actually looked to American Jim Crow laws to see how Americans defined being Black. And in fact, somewhat ironically, some of the Jim Crow laws, which defined anyone who was a so-called octoroon, 1/8 black blood, as being black and not white, Germans at the time in 1935 thought that was overly going over the top, and they thought they're not going to go so far as the Americans in saying that even 1/8 Jewish blood is sufficient to constitute someone as Jewish. And then again, in 1941, there was another, basically a kind of a law that was passed that really kind of then stripped the German Jewish subjects who remained in Germany at the time of all legal rights whatsoever.
Okay, well, thanks. We have so many great questions. I'm hoping we can get through as many as we can. There's this great one here. Under current international law, is it easier to hold mass murderers or perpetrators of genocide accountable, even if the laws in the state where the atrocity took place are weak or immoral?
Well, again, I suppose there are two questions that you have to answer with that kind of question. As a doctrinal matter, does international law now offer a more robust device for bringing these perpetrators of mass atrocities to justice? And the answer is certainly yes. And we have institutions such as the International Criminal Court, a permanent criminal court that has supplanted the need for ad hoc institutions like the Nuremberg Court, which is there basically to enforce international criminal law. The other question is, again, whether a state is kind of willing or to surrender its subjects to an international court. And that, again, remains a very fraught subject. And so I think we have to kind of balance the doctrinal innovations and progress that has been made against the real world recognition that often it's very, very difficult to bring these perpetrators of mass crimes to justice.
Thank you. I thought this one was interesting with one of our participants. How does the concept of sovereignty work into this analysis? They're saying that in their current work, they define sovereign as an entity that doesn't need to ask for permission or forgiveness. The temporal element is not invoked in the definition, which is problematic.
Right. So the notion of sovereignty, again, if you go back to kind of international law before Nuremberg, really kind of even going back before, let's say, World War I, international law basically stood for two very powerful propositions. That is the right of sovereignty. One was a state can go to war against whomever it wants for whatever reason it wants. And secondly, the state's treatment of its own legal subjects is its own business and no one else's. And neither of those propositions basically survived the Second World War, in particular the second. This notion of the recognition of crimes against humanity and genocide as international crimes basically establishes a kind of radical new understanding that if a sovereign engages in these kind of systematic abuses of members of its own population, that is not something they can do with impunity. That is a matter of international concern, and it constitutes an international crime, even if it is permissible under domestic law.
Okay, I have so many questions. Okay, hold on one second. I'm going through all. There's a lot of really great ones. Here's one. Okay, did Germany's civil law system and lack of a functioning jury system, which would have given normal citizens some say in criminal law, facilitate the creation of the, I hope I don't butcher this, Bürgerstaat? Did post-war Germany consider introducing a jury system for this reason?
Well, as we know now, Germany doesn't have a jury system. And in fact, the book that Ruth mentioned earlier that I wrote, this Right, Wrong Man, which was about the Demjanjuk trials, I was there observing it. And for an American, for someone schooled in American law school, it was really quite remarkable to see a trial being conducted without a jury. The other thing, again, maybe this isn't directly responsive to the question, but the question does give me an opportunity to make this kind of interesting point, which is, there were courts that were still in operation in Germany during the Third Reich, and there were civil suits that were brought, and sometimes these courts did arrive at some pretty surprising decisions, given the fact that they were operating within a authoritarian, totalitarian society. But one thing that I should say is that Jews who, by the courts in Germany, were convicted of crimes had a better chance of surviving than those who were just citizens or subjects from other countries who were then, let's say, deported to or sent to to killing centers. And ironically, the reason that is because to be convicted of a crime is to have a legal identity. Whereas Jews who were sent to these killing centers, they basically had no legal identity at all. And so you see this kind of incredibly bizarre result that, again, that the survival rates of Jews who had been convicted of crimes was actually higher than Jews who were just sent as regular, ordinary people to killing centers.
I had to put my glasses on, sorry. Hi. Here's one. I don't think this one's answered yet. When dealing with the punishment of war criminals and those who commit genocide, how important is it to your mind that those categories of crime are employed? In other words, how much does it change things for someone to be convicted of genocide versus being convicted of hundreds of thousands of counts of murder?
Yes. And again, I think this is something where I honestly don't want to make, this is totally not me trying to make a plug for the book, but in this book, The Right, Wrong Man, it deals exactly with this question. And it really is a terrific question. And it's a really important question that is, can we understand, can we conceptualize, acts like the Holocaust as simply murder repeated 6 million times, or is it necessary to have really kind of a different concept in place? And I would say both as a conceptual matter and as a legal matter, it is important to have this separate concept in place and not to treat a state-sponsored extermination simply like a garden variety convenience store murder repeated over millions of times.
Thank you. This one's, I thought it was pretty interesting. What checks and balances were missing in the Third Reich that permitted transfer of legislative authority to the executive? And are there any parallels, I guess, today?
Well, again, I don't necessarily want to get too much into some of the challenges that we're confronting today. But I do think it is important to bear in mind that the German Constitution during the Weimar Republic had a really very substantial defect built into it. And this was the so-called Article 48. And the Article 48 basically created the opportunity for the leader to basically rule by emergency decree. And by ruling by emergency decree, it really kind of opened the door for dissolving all sorts of parliamentary checks. And at the same time that I recognize that all forms of constitutional democracy are vulnerable, I do think it's important to bear in mind that, for example, our Constitution doesn't have any kind of similar Article 48 that permits this kind of rule by extemporaneous decree.
Thanks. I think we have time for maybe maybe two more questions. And there's so many coming in. So as I'm even telling you the question, we're getting more. Okay, here's one. In addition to the prohibition on double jeopardy, was there similar obligations regarding right to counsel, effective assistance of counsel, and right to trial by jury?
Again, the short answer is certainly not a right to jury. because again, there is no jury system in Germany. And I really should say that Germany does not have an adversarial model of justice like what we have. So for example, I would say at the most basic level, our adversarial system of justice lets the parties themselves control the flow of information, and the judge is a relatively neutral bystander in the case. And of course, the jury is what's called the trier of fact, though that itself is perhaps not the most perfect description. In Germany, it's the judge that actually controls the flow of information of the court. And in many respects, the prosecutor is only responsible for preparing the indictment, and sometimes defense counsels play very little role as well. Really, the trial process is controlled by the panel of expert judges.
Thank you. We're going to do one more question. We're a little bit over, but we have so many really amazing questions, and we'll kind of go from there. But real quick, Lawrence, if people have additional questions, can we pass them on to you afterwards?
I think the answer is yes, even though I am a little overwhelmed at the moment. I will try my heart, because I really do try to make an effort to respond to questions. But anyway, I won't go into, yes.
Lawrence is a very busy professor. So this last question I thought was great. Do these concepts such as crimes against humanity fit into civil lawsuits? Thinking of the Tulsa Massacre lawsuit that was just filed again, asking for repairs.
Yeah, I think that's an excellent question. And they certainly, absolutely, they certainly can. I mean, they certainly can be used for things like, wrongful death lawsuits, even though I should emphasize that that would have to occur on in a domestic national court. That is, if we're talking about kind of an international court like the International Criminal Court in The Hague, that would not be able to, that is exclusively a criminal court. It is not something that can deal with these kind of civil proceedings, even though you do have the International Court of Justice, which deals with civil proceedings, but only between nation states themselves, not between private individuals.
Okay, well, I think that's going to be the last question, Lawrence.
Okay.
And we have so many that I think we could probably do questions for another hour.
Yeah.
I just want to thank you again for today's powerful presentation. It's the first CLE we've done in quite some time, and we've just been amazed by how many people were just interested in participating today. So we're just so excited to have had you be a part of that. And a huge thank you to the staff of the Holocaust Center for Humanity, who have worked really incredibly hard to, continue to offer these programs virtually to our students, teachers, and community members during this challenging time. And again, as I mentioned to everyone, please email me your affirmation form. I'm Nicole Bella, and the Director of Development at the Holocaust Center for Humanity. And I will be, filing for everyone's ethics credit sometime soon, once I have all those in. So if you can get those into me for the next week, that would be great. And we are happy to offer you the ethics credit for this program. And again, thank you to all of you who are joining us for the first time. We hope that you'll continue to engage with our programs at the Holocaust Center for Humanity. If this is your first time joining us or even hearing about us, we hope that you'll consider joining us for our virtual Lunch and Learn series coming up every Tuesday at 12 p.m. In addition, as Dee mentioned at the beginning, we have our first ever virtual Voices for Humanity luncheon, where we will be celebrating the impact of the center and the work that we're doing. And it's a great way to just come and learn more about the work of the center. And we hope that you'll consider registering for that. And I have the links in this slide for you to take a look at. And again, that is it. And we're just so happy you could all join us. This has been a phenomenal program, and we hope we can continue to do additional programs like this into the future. So thank you again, and enjoy the rest of your day.